We're very lucky to have with us four of our esteemed European colleagues. Working from the right, we have Marie Koop from Belgium, Martin Rijks from the Netherlands. A particular thanks to Martin. It's taken him about, a day and a half to get, 12 hours to get here. Terrible time at the airport, so we're very pleased to have you. Olaf Gillert on my left from Germany, and Inès Triboulet from Paris, from France. So you can see that we've got a good range of European people in front of us here, I'm pleased to say. So before picking their brains, I'm just going to set the scene very briefly for you. First of all, in spite of the letter B that's everywhere, that doesn't stand for Brexit. This is a non-Brexit Brexit talk. There's going to be no mention of cloned rights, comparable rights, interpretation of the withdrawal agreement, or when UK law will start diverging from European. We're not getting into any of that, you'll be very pleased to know. Instead, this is about the laws and procedures which apply in the EU, and in particular how they vary somewhat between different countries. So, let's say you're in a position where you need to rely on EU trademark rights against an infringer, and the infringement's being carried out in more than one EU country. How do you choose where to go, where to take action? And that decision is going to be based on a mix of the law, jurisdictional issues, and being familiar with the very different approaches, well, not very different, but there are differences, different approaches and quirks that you get in different European countries. So as in many other areas, EU law isn't actually that harmonised, and the savvy litigant can actually steal a march by having a really good strategy up front and deciding how to go about bringing its infringement claim. So the format of this session is going to be to run through, at a pretty high level, the jurisdictional issues which apply to EU trademark enforcement, to do that very quickly. And then, with the expert help of my esteemed colleagues here, to go through the differences which arise between the different countries. In particular, because we're mainly a UK audience, I assume, we're going to be picking up on things which are a little bit different from the UK, because if they're the same, they're not so interesting. And also bear in mind, obviously, we're covering 4 European countries here, and we're not going to try and cover the other 20, however many it is, without the UK now, because we'd need rather more than the next 40 minutes to do that. But we will give you some interesting snippets across some pretty major countries we have here. So, in particular, we're going to focus on 3 main things: enforcement of an EU trademark, suing under a national mark, which is obviously a possibility as well, and then importantly, how you go about attacking the validity of a national mark, which can also play into where's the best place to go. So before we delve in with with my colleagues here, just a little bit of general law. Don't worry, not too much. But there are rules, as probably a lot of you will know, about where a claimant can sue when it's relying on an EU trademark. And they're set out in the EU trademark regulations, articles 125 and 126. In a nutshell, the claimant has a choice whether you want to obtain relief in just one country or several, or indeed potentially all EU countries. If you're only interested in one country, say you've got an infringer in Portugal, that's the only place it does business, you only need to sue them in that one country. You can go to Portugal, you can do it wherever you like. In fact, there's no rules here. You can choose. But if you're looking for a remedy which goes to more than one EU country, or indeed to all of them, then there are rules that tell you where you have to go. The start point is if the defendant is in an EU country, based in an EU country, you have to bring the action there. If they're non-EU, so let's say you've got, a US defendant, then the next thing you look at is where's the claimant based. And if the claimant is EU, then the claimant can bring the claim, in fact needs to bring the claim in the country where it is based if it wants to get pan-EU relief. And if neither of them are EU, then you end up in Spain in the Alicante court. This is where you're wanting to go for remedies in more than one country. So wearing my UK hat for a moment, and many of you will be wearing similar hats, that does have an impact on us now. We're sadly no longer part of the EU, because as a UK company, it means that if someone is going to want to take action against you as a UK company, they no longer need to come to the UK, because that's not the rule. We're not part of the EU anymore. So they can turn it from an away match, if you like, into a home one. And if it's a German company, they can take you to the German courts, which is obviously quite a big deal if you're a UK company having to fight a case in the claimant's territory. The other way round, if you're a UK company wanting to bring an action, obviously if it was against a German company, the same rule would apply. You had to go to Germany anyway, you still do. But if you wanted to bring an action against a US company, you wouldn't have the ability anymore to base it in the UK, which you could have done. You'd need to go to Alicante in Spain. So it does have quite a big impact on UK companies. Where do we get to? Is that what I've just been through? No? Oh no, sorry, that's online infringement. Right. Before we come on to other choices that you can make, one key factor is where an infringement is taking place. And online, as most things are, or many things are these days, is obviously a key one. The internet is generally fairly agnostic about territory, not necessarily, but it often is, open to anyone to buy products from that website. May not be, but it often is. And until recently, there was a question mark about where's the right place to take action against a website that you don't like. Is it A, where the people who are targeted, the consumers, are based, or is it in fact where the website is operated from? In other words, where the website owner is based. And it was an unknown topic until about 3 years ago, a CJEU case, a case called Neve, which I think we probably all know now, that you look at where the consumers are based as long as they are properly targeted, and you can demonstrate that they're, you could buy from France or Spain or wherever it may be. And that obviously has quite a big impact, because it tends to mean for an online case, you can choose your country, other than when you're going for a kind of pan-EU relief that we were talking about. So, this is where we get to the nitty-gritty, and then you stop hearing from me and start hearing from my far more interesting colleagues here. There is some latitude, as you'll have picked up as we were going through there, about where you might choose to bring your action. And in deciding where you want to do that and the best strategy for it, there are lots of factors which are in fact not particularly harmonised in the EU. And with the help of our panel here, we're going to discuss some of the main factors that you might want to take into account. We can't cover everything, but we are going to cover some which will hopefully chime and be interesting to you, and therefore relevant. So, two of the first questions, I'm sure if someone in your, a client or your in-house client came to you and said, right, we need to take action, where should we do it? I'd have thought two things are going to be playing on your mind straight away. How long does it take in that country? And secondly, probably even more importantly, how much does it cost? They're always going to be the two things, or two of the main things you're thinking about. So, let's get our panel talking now. Enough from me. I'm going to ask each of you, just how long would you say a normal, average trademark infringement court case, not an accelerated one, not a preliminary injunction, just a normal case, from beginning to end? Inez?
Well, in France, an action on the merits will take around a year to a year and a half.
Okay.
From the filing of the action to the issuance of the decision.
Okay. Can you beat that, Olaf?
Yeah, we can. Actually, it's 6 to 9 months. And, but if you go to appeal, it very much depends upon the Court of Appeal. it might be anywhere between 1 year and up to 5 years for an appeal case, which is outrageously long.
Okay. Martin, where's the Netherlands?
We can't beat Germany. I think we're in the same range as France.
Okay.
Although the Dutch courts have quite a backlog on work, especially in IP cases.
Okay.
So, to be honest, I think it's more 1.5 to 2 years right now.
Okay. Marie?
More or less the same as France for first instance. So around a year. It could be a little more depending a bit of how the case is managed.
Okay.
But yeah, appeal can be a very big incentive to settle.
Okay. Just to join the dots, because we mentioned Alicante, which may become more important for UK companies, the timescale there is around 12 months. So, you know, we've got some differences, but it's not hugely different in there. Now, on costs, there are kind of pluses and minuses going into Europe compared to being in the UK. Typically, European countries' legal costs for taking a case to trial are cheaper than the UK, although, you know, we heard from Colin Burse earlier on how things are changing. And many of you will be familiar with IPEC, which is an easier and cheaper way to bring an IP case. So it's not as stark as it might have been in the past. There are cheaper ways, more streamlined ways to get to an outcome in the UK, which maybe makes the cost difference a little bit less. But on the whole, probably going into a European country is a bit less expensive than we're used to here. The downside is that as a percentage of what you can recover from the other side, assuming you succeed, that percentage is generally a bit lower than it is here. Not always, it just depends, because I know some countries you've got scales of cost and it depends on either the value of the claim or what's involved. But generally, if you take a broad brush approach, the percentage you recover is a bit less, in some cases a lot less than it would be here in the UK. Right, so we've spoken about speed. Obviously, if you're thinking about wanting a really quick outcome to a case, the first thing you might think about, or the other party might think about if they're coming against you, is what about a preliminary injunction? Is that something you can do? And how does that work in different countries? So one key thing that we're used to in the UK is that you can't mess around if you want to bring a preliminary injunction. It's an urgent remedy. Therefore, if you faff about and take 3 months to get before the court's going to say, well, it can't be so urgent, we need to give you a preliminary injunction. So, you know, you get ruled out for that basis. But things vary. So again, let's go the other way this time. Maybe start with you, Marie.
So yeah, urgency is a condition to apply for a PI, and the behavior of the claimant will be taken into account. So if you mess around and wait too long, the judge could consider that there's no more urgency. And say if I had to put a number of it, 1 month, 2 months. As a defendant, if there's no particular circumstance that would justify why the claimant waited for a PI, as from 1 month I would try to invoke the lack of urgency.
Okay. Yeah. So Martin, a bit different in the Netherlands, I think.
Very different, yeah.
How long do you get there?
It depends. Urgent interest is always decided on the facts and the circumstance of the specific case. But in the Netherlands, you can get away with 6 to 9 months, usually rather easily. So instead of proceedings on the merits for preliminary injunction proceedings, we can beat the other jurisdictions on that.
And obviously that's important to know, depending on which side you're on, because if you're a UK company and you're used to needing to move quickly, and someone's trying to bring that kind of PI injunction claim against you in the Netherlands, you might start by thinking they're too late if they're 4 months on or 5 months on, but that's not necessarily the case. Germany, I think, is quite strict, yes?
Yeah, most of the district courts apply a 1 month time frame for bringing the preliminary injunction. That's extremely strict. There are a few courts, they have up to 2 months, but just out of the 100 and something district courts, I think only probably 5 or 10, you have 2 months. So better calculate with 1 month, and then you're on the safe side. And that's strict. That's not negotiable. If you try to negotiate or suspend the conflict, that's not possible.
Okay. So Inez, I know there's probably no complete rule as to what the time period is, but what would you say as a rough guide would be an acceptable period?
Well, it really depends on the type of proceeding. We have different type of PIs. Some of them require urgency, others don't.
Okay.
And for the urgent matters, I think that we could obtain a decision in a month.
Okay.
But for other PIs, which are requested only to prevent an imminent damage, I would say between 2 and 6 months.
Okay. We haven't got any of the Taylor Wessing colleagues from Austria, but I do know that things are pretty relaxed there in terms of timing, possibly even more relaxed than in the Netherlands, definitely at least as relaxed. Again, filling in the gap for Alicante, I'm told that's about 3 months, so somewhere in the middle of all of that. So continuing on the theme of preliminary injunctions, I mean, one key question, whether you're a claimant or a defendant, is can you get a preliminary injunction ex parte? And that used to be one big reason why people liked going in Germany, because it used to be very claimant friendly from that point of view. And Olaf will put me right if I've got this bit wrong, but I'm going to ask you the current position rather than the old position. The old position certainly used to be that you could go ex parte, you could choose which city you wanted to go to, so you'd find a favourable court that you thought would find in your favour. And what was even better about it was that it was effectively secret, because if you made the application and the judge didn't like it and said, sorry, I'm not going to give it to you, the other party would never even know about it. So you had a kind of shot to nothing. You could choose your court, go for it, obviously hope for the best, and if it failed, you were no worse off than if you hadn't tried in the first place. So for a claimant, it was like magic, this is brilliant. Germany is the place to go. But I think it's not quite the case anymore, Olaf, is that right?
Yeah, exactly, that has changed. And what a surprise. At one point it was brought up to the German Constitutional Court, and speaking about fairness in such trials, the court said, well, that's not too fair with regards to the defendant. He has no saying, he has no chance to defend himself. So the Constitutional Court basically ruled against this practice. That was a practice, well, that was, over the years it was established among the courts, and that has been abolished now. So the entire preliminary injunction proceedings are now being ruled by fairness, which means that you have to give the other side the chance to submit, only to give the chance to submit their arguments. And if the other side actually defends itself, you have to submit it with a request for your preliminary injunction. If this other side does not reply to your C and D letter, you can tell it to the court with the PI, and then it will be decided without the defendant's motion. But the other side, the defendant, has to have the chance to submit its argument.
Okay.
So.
And what that means, because of that change, I mean, going back a few years when it hadn't changed, I mean, I've got at least one client I know who, and there's others of you may have done the same thing, if you're worried about that possibility happening in Germany, as a defendant, you could file a sort of in advance defence called a protective writ or a protective brief, which would get lodged with the court in a sealed envelope, in effect. And if the court then received an otherwise ex parte application, the court would read what the defendant had to say. But although that's still in theory, or you can still do it, the need for it has effectively disappeared if you can't go ex parte against someone anyway. So I think I'm going to ask just quickly the other panelists that, except for particularly urgent and exceptional preliminary injunction cases where you really can't and shouldn't need to go ex parte, the general rule is that you can't. Is that right? You have to tell the defendant. Mm-hmm. Is that correct?
Yeah, it would be really in exceptional cases that you could get an ex parte PR.
And same Netherlands, I think.
Same in yeah. So
yeah, same.
Okay.
They are limited to very extreme urgent cases,
okay,
or cases where you want to establish proof and the defendant shouldn't be part of the proceeding, exactly, such as seizure infringement proceedings.
So the kind of, unless you're in one of those highly exceptional cases, which are going to be very exceptional, you can, as a possible defendant, relax a bit because you know you're going to get a chance to defend yourself. But as a possible claimant, you've at least lost that nice way of going about things in Germany, potentially. Okay, what about, so preliminary injunction is often the quickest thing of all. The next quickest, if you're not going to carry on the whole way through to a trial in whatever it might be, ranging between 6 to 9 months to maybe 2 years, is can you go for a speedy trial, as we would call it in the UK, or accelerated proceedings, which is another term which is used, because that might be another way of getting an outcome quickly when either you don't want to go for a preliminary injunction or you've left it a bit too late for that. So is that a possibility in France, Inez?
Yes, but again, it's quite limited. So basically, you choose that option when the case is not that obvious, so that you can't choose the PI proceedings option. But you need to prove that the case is ready to be heard by the judge.
Okay. Okay.
So,
bit like Lord Justice Burst was saying about a case in 2 weeks. But Maria, I think that's quite a good way in Belgium, isn't it?
Yeah, the accelerated proceedings is one of the most common proceedings which is used in Belgium because it's injunction proceedings on the merits, which uses the form of a PI proceeding. So it's usually a bit longer than a PI proceeding, so it would be more around the 6 months or 9. But in the end, you get a final injunction. So it's very, very liked by brand owners. And the only thing is that you cannot ask for damages.
Okay.
So, and it's also one of the reasons why judges tend to be a bit more strict on the urgency in PIs, because there is this option, because in accelerated proceedings, you do not have to demonstrate urgency.
So actually, they're probably more common than PIs.
Yeah, usually you go for a PI really if, because one of the conditions for PI for urgency is to be able that you wouldn't have been able to get a decision through using another proceedings.
Okay.
And so here the accelerated proceedings is usually used. So it's the PI is used if you have a good, if it's urgent and you have to act very quickly.
So in the Netherlands, I guess, because you have time before you have to bring a PI, you don't need this. Is there an alternative of this kind of process or not really?
There is an alternative under Dutch procedural law, so you can ask for basically a PI for the course of the duration of proceedings on the merits. You have to file that immediately with your writ of summons, but in practice, judges simply move that decision to the end decision in proceedings on the merits, so it will not help you very much. So then you will definitely go for a PI.
Okay, thank you. So the next thing on my mental list is forum shopping. So in terms of which country do you decide to go in? Obviously we touched on that earlier on. If it's an EU trademark and you're after relief in more than one country, or indeed possibly all of them, then we've been through the rules for that and you don't have any choice. But of course you can always choose, even if you're relying on an EUTM, to only go for relief in one country, in which case you can choose which country you want, as long as you can demonstrate that the infringement is happening there. So you've always got that option, which may or may not be a good one. It will depend on strategic reasons, but you can do that as well. Obviously, when you've got a national trademark, then you're going to be going in that country anyway. But within each country, a question is how far can you forum shop by deciding which court to go to or which city do you decide to issue your claim out of, on the basis that maybe one court is more brand owner friendly than another and it suits you therefore to go there. So can you do that, Martin, in the Netherlands?
You can, yeah.
Okay.
So you basically, for proceedings on the merits, if you base your claim on an EUTM, you have to go to the court in The Hague.
Okay.
But if you want to apply for a PI, you can do it everywhere in the Netherlands. But you have to show that the court in that territory has jurisdiction, for example, because the offer of the infringing product was made in that territory.
Okay.
But as you said before, since most of the offers are made online, it's rather quickly to show and to prove that the public in that specific territory was also reached by this offer.
Okay. And would you say, are there some courts which are more brand owner friendly? Is it worth choosing sometimes?
I think Amsterdam and The Hague would be the most, and Rotterdam would be the most brand owner friendly.
Okay.
But because of the backlog in The Hague, you see that a lot of proceedings are now filed in Rotterdam and Amsterdam,
Okay.
which have less specialized IP judges. So it depends a little bit on which side you're on.
Okay.
So if you have a weak case, then you might want to go to Rotterdam instead of going to The Hague.
Yeah.
So you can choose on that ground as well.
Okay. So France, I think, is a little bit less flexible in terms.
Yes, forum shopping is quite limited in France because we have specialized courts. So we have 10 courts which are specialized in IP matters, and the territorial jurisdiction then is decided depending on where the defendant is located or where the damage occurred.
Okay.
So you need to. The rules are quite defined, and you need to pick the court, the competent court, depending on that.
What about Belgium, Marie?
Well, it's a bit the same as in France. We also have a kind of centralization of the matters before Benelux trademarks. It's before 6 courts. It's the courts where there's a court of appeal in the district of a court of appeal. It's 5 cities, but in Brussels you have to know that we have a French-speaking tribunal and a Dutch-speaking tribunal. So you have to go in front of one of these tribunals. And one thing is, depending on the city where you're going to, the proceedings will be either in Dutch or in French. So that can be a reason to choose one or the other.
And maybe good to add that if you rely on a national mark, you can also choose between Belgium and the Netherlands, because we don't have our own national marks.
Yeah,
so
true. Good point.
you need a forum shop between the countries.
So Germany, again, used to be the place where you really could forum shop to your heart's content, but I think that's tightened up a bit again, hasn't it?
You're right, Jason. You can still do forum shopping, but it's not as easy as it used to be, and it is still like in the Netherlands. A simple offer on the internet is not sufficient. In former times, you could simply download the offer from the internet and say, well, it occurred everywhere in Germany, so you could choose the court you wanted to go to. Now, the mere offer on the internet is not sufficient any longer. What you can still do is you can make a test purchase in any district you want to go to court, and when it's delivered, you have the infringement at the district, on that district court level. So it's still possible.
Okay. Right. Well, we've still got 1 or 2 factors up there we haven't touched on. And Marie mentioned language, and that's obviously always going to be an issue if you're a UK company, particularly, having to work in a local language in the country you're going in. So a practical point to bear in mind, of course. There's a mention up there, what's the IP expertise of the various courts like? Well, it was mentioned earlier, I'm not sure if it was Roland or Lord Justice Burst that, I expect it was Roland, I don't think Lord Justice Burst would have wanted to comment, but Roland was asking him to do more trademark cases because certainly in our Chancery division, which is, where we need to go in the High Court, it's, you might get an IP specialist judge or you might not, so that's a disadvantage here. IPEC's obviously different because you've got a specialist IP judge, another reason to at least consider IPEC. I'm not going to ask each of you because of time, but the general rule across certainly these 4 countries and also Alicante is that they are more IP specialists in the courts that you go to. So you don't have quite the same situation as you would in our Chancery division. So we've dealt with infringement actions. A related subject is, I put cancellation actions, so I mean either invalidity or revocation. And they can be quite key as depending on which side you're on, can be a very good strategic move as a defendant. Many of you will know, what's known as the classic EU torpedo, where if you get wind of someone about to sue you on the basis of an EU trademark, then you can really mess them about by getting in first and filing either an invalidity attack or a revocation attack at the EU IPO. And that means that then any infringement proceedings which come later, excepting preliminary injunctions, they kind of override it, but normal proceedings have to wait until the general rule is they then have to be put on hold until the EU IPO has made its decision on your claim. And that can obviously take some time. So that's a pretty potent weapon to have in your armory as a defendant. But of course, there's also the possibility of a national torpedo. It doesn't necessarily have to be an EU one, but that's only going to work where you can bring your cancellation action in the IP office, because obviously if you have to bring it in the court, you don't gain anything, because if you start in the court and the other person sues you for infringement, it's just going to all happen in the same court case, so you don't get the nice delay factor from going to the IP office first. So I'm going to ask the panel now, because it's a key question. Can you bring a cancellation action, either invalidity or revocation, in your IP office rather than needing to go to the court? I think maybe it's Ines' turn.
Yes, actually, the French Trademark Office has exclusive jurisdiction over invalidity actions. You can still request for the revocation of trademarks before courts, but only as a counterclaim, or if you bring other claims such as an infringement action or an unfair competition action.
Okay, and have you got a good chance, if you do that as a defendant, if the claimant then, or the other party then, brings infringement proceedings in the court, have you got a decent chance of saying to the court, please suspend the infringement proceedings until the other...
It's not automatic.
Okay, but it's maybe.
Maybe.
Okay.
You have to request it.
Okay. What's the story in Germany then, Ola?
It's pretty much the same as in France, but you can bring in validity actions, cancellation actions with the courts or with the German Patent and Trademark Office. But there's no automatic stay for the infringement action.
Okay.
And the judge has to, actually the court has to decide, internally decide whether the invalidity action has a chance to be successful. And only then it will suspend the infringement proceeding.
Okay, and Netherlands?
It's more or less the same as in Germany, so you have to request the suspension, but the court usually will suspend the infringement proceedings.
So it's quite a good strategy then.
So it could be quite a good strategy.
Okay.
Yeah. But on the other hand, you can then probably parties will go for a preliminary injunction.
True, okay, yes,
because
more time.
it's more time.
True, you're right. It's checks and balances going on in there. Marie?
It's more or less the same. You have to request it. It's not automatic, and it will but the judge will really make a balance. So it will depend a little bit on the situation. If he sees that if you can demonstrate, but that's not easy, that there's a decision of the office, that the decision of the office is coming soon, you have greater chances. But yeah.
Okay. I mean, there used to be more countries that required you to go to the court for a cancellation action. But there's actually a European directive which is forcing countries to make it possible to go to the IP office. I think the deadline is sometime in 2023. Yeah. So Spain, for example, is one that needs to change its ways. It has, or it does need to? Need to, yeah. Sweden, bizarrely, has come up with, at the moment you have to go in the court. They think they're solving it by saying you can start your cancellation action in the IP office, but if it's contested, then it has to go to the court, which doesn't really work. And I think they might have to think again on that one. But they are, I think, is that how it used to be in Germany, or have I got that wrong?
Yeah, it used to be like that.
Yeah, okay. So anyway, I expect Sweden will have to toe the line as well. Right, some other quick quirks for you. Talking of Sweden, something to bear in mind. Some of you may have come across it, but it's not very intuitive. A Swedish company name, as long as the company is trading, and it doesn't have to be trading to any great extent, gives rights in that name. So it's not like in the UK where you have to build up enough rights to show goodwill and passing off. It's just having a company with that name that's operating gives you rights. And it gives you rights, exclusive rights in that name to prevent someone else doing it. So it's kind of like having a trademark. So for those of you who get involved in clearance searches, you'll now know why Swedish company names have to be looked at, because they are kind of like a trademark in effect. So one obvious quirk for Sweden. What have I got next? Austria. Apparently, if you're in a preliminary injunction situation, the judge can decide to call you in to cross-examine you, which is obviously not something we'd get over here. So be aware of that. That's a possibility. Yes, it's a Benelux one. I think this was one from you, Martin, which is a different ground of trademark infringement when you don't need to show use and affecting the trademark function in effect?
Well, you have to show
Sorry,
affecting the trademark function.
Not showing use on goods and services.
Exactly. Yeah. So we have an additional ground for trademark infringement where you can also rely on your Benelux trademark rights if someone else uses your mark differently than to distinguish its own goods and services. So, for example, in a press release or an advert, which is clearly not used to distinguish their goods and services, but if it's detrimental to your reputation or if it's taking unfair advantage of your reputation, then it's still possible to rely on your trademark rights, which makes it a little bit easier than go for an unfair competition case or comparative advertising, and it gives you a more beneficial procedural cost reward if you win the case.
Okay, another one to put away in the back of your mind, to pull out of the hat at some point. Just to finish off on Alicante quickly, because we've made references to it as we're going through. The courts there, I would say, are, in terms of their IP specialism, are solid without being stellar, so not too bad. Cases take about a year, I think I mentioned that before. PIs, you can do it up to 3 months typically. And actually quite surprising, you'd think there'd be a lot of these cases given the rules that if you've got, 2 non-EU parties, you'd think there would be quite a lot of these cases going on. But they only have, I'm told, each year in the tens, in the 2 figures of cases going through, not in anything more than that. So it's not, you'd think there would be a lot more, but maybe people get scared off at the thought of, mind you, Alicante's probably not bad, depending on the time of year, I suppose. But anyway, less than I would have thought, and quite interesting.